We're almost there. Just be patient. Okay, there we are. We are now live and with our guests. So first of all, let's get started. It is 3:29. Oh, I don't know. we gotta wait for that 3:30. I'm sorry. Hey, Marty, are you still in Hawaii?
I'm not. I'm back in Utah in the cold.
I'm so happy when you're there. All right, welcome everybody to KoreSummit Webinar Series 2021. My name is Oscar Joffrey. Myself and with my colleagues here, panelists this afternoon, we're going to have a fun discussion. For those of you that are new to it, our format is very simple. We have no presentation. This is purely for you to listen to the real hard knocks of people doing the work, not reading PowerPoint slides. And we're gonna have a conversation for about 45 minutes and give you an opportunity to put up your hand. There's a little button there with a hand, click on it, ask your questions, and of course, ask that of our panelists. So I'm gonna get our panelists to introduce themselves one by one. So let's start with Marty.
Hi, so I'm Marty Tate. I am a partner at the law firm Carmen Lenhoff Tate Israelson in Salt Lake City. I've been practicing securities law for about 20 years. A large chunk of that in the crowdfunding space, doing Regulation CF, Reg C offerings and a lot of Reg A offerings. So active in that space. Met Oscar, I don't know, a dozen years ago or so, when we were both infants. So most of my clients are either platforms or issuers or service providers in this space.
Perfect. Thank you. Great to have you alongside. Jonathan, please. You're on mute.
Sorry there. Sorry, I had the mute on. Jonathan Whaley, I'm the Chief Compliance Officer for WonderFund. WonderFund is a crowdfunding portal out of Cincinnati, Ohio. And we kind of focus on the underserved markets, Midwest, Southeast, as well as demographically with minority-based companies, LGBTQ, female founders, people of color, and that nature.
Oh, fantastic. So let me get the afternoon started with some really good news, because there was something buzzing about, obviously with a new election, with a new administration. Marty, you probably got wind of this, that the new administration had issued a letter to halt all incoming changes, and today was the day we were waiting for, whether the SEC was going to halt the new amendments or proceed. We're very excited. We proceed. March 15th is still the day, which is great. A lot of champions at the table, Marty, and I'm sure many others were there as well. So for everybody that's listening in here today, we're a full speed ahead for $5 million for Regulation CF and $75 million for Regulation A. So let's get this great discussion going today. It should jive up everybody. This one is very dear to me right now, because I'm sure for the two of you, I'm spending a lot of time trying to answer this question, and there's kind of mixed dialogue on it, but hopefully today we'll have enough of a dialogue to get it really sparked up. So the regulators have provided this new structure, well, not a new structure, but a structure to be utilized under RegCF, SPV for RegCF. So we'll get to that why for the for the RegCF, but let's unravel it first of all from the legal perspective. What is an SPV? Why? How has it been used to date? And then we can start going into, with you, Jonathan, how's that going to move into for a Regulation A company? So Marty, let's kick it off with you.
Yeah. And just to be clear, we're talking about SPVs, not STDs.
Oh, shit.
And, so SPV stands for Special Purpose Vehicle, and or sometimes they're called SPEs, or Special Purpose Entities. Used a lot in financing with where you'll where you're raising capital for a specific purpose. Used a lot in like infrastructure deals or real estate deals where people will come together and invest in a real estate project. Or come together to do into an equity investment, to then do a debt financing or something like that. So one of the rules with RegCF prior to this amendment was that you couldn't use SPVs. Basically, all of the investments had to be made directly into the operating company. So this created a couple of complications. One is that if you raise money from a large number of shareholders, you had to, and you were going to do that selling stock, you had a couple of problems. One was that your cap table suddenly has 400, 500 investors, 1,000 investors that have all come in your RegCF offering, and so that's bad because it might hurt future rounds and turn off a Series A investor or something like that. The other is under Section 12G, if you have more than 2,000 investors total or more than 500 non-accredited investors, you're required to register as a public company, which means you have to go through that process of registering. You have to be a fully reporting company. So there was a problem there with equity investors. That's why a lot of the crowdfunding platforms have used like a crowd safe instrument, because it's not equity, it's not clogging up your cap table or making you subject to Rule 12G or Section 12G. So that has been a problem. So one of the things that a lot of us started petitioning for immediately, even before the Jobs Act and the rules came out there, was allowing the use of an SPV, an investment vehicle where your investors invest specifically into this newly formed, most likely an LLC, a pass-through entity. The investors all go in there, and that SPV then turns and makes the investment into the issuer or into the project itself. So to me, this was, the 5 million I think is great, but to me, this is the most significant change in the amendment.
And so obviously the vehicle itself has been around for a long time. So we've seen it, I often hear it mostly in real estate. Anytime people talk real estate, oh yeah, they're in an SPV. But now we're bringing it into this new arena where it's not an issue whether you're a young entrepreneur or not. It seems really exciting. And obviously we're going to go to you, Jonathan, now, because you're being the CCO of a funding portal. How do you see that playing out for you as a funding portal? How do you see that structure materializing based on what people have a perception of it?
Yeah, so it's definitely going to be interesting. SPVs, obviously, we're not a part of anything we've dealt with so far. And so a lot of the issuers that have come to us, most of them generally not being as sophisticated on the law as securities attorneys, probably didn't even know of the existence of SPVs. But now it's been blasted out. Everyone heard that there's this special purpose vehicle, and that's kind of the new buzzword for what issuers want to do. So it's going to be interesting because I think, especially with the increase to $5 million, it's going to be much more relevant. When you're raising $200,000 and you get 50 to 100 investors, it's not too difficult to deal with that from a cap table perspective. But as Marty mentioned, if we're truly looking for unaccredited investors and you're putting very small minimums up to $5 million, you're going to have to account for that. Of what, complying with the securities law, specifically that 12G, but also from a business standpoint, if you're an issuer, you're going to need to understand how to organize these investors and, just comply with all of the rules you have to as far as communication and cap table management and all of that. So there's definitely still, I think there's more questions from the issuer side right now than there are answers. But it's great because I know, like people like Marty and Core, and there's a lot of other groups out there that are getting out this information, and conferences like this especially are really important because it's definitely, we had not heard the word SPV from an issuer before, and we've probably heard it 4 times this year already. So that's kind of where it's at.
I agree. I mean, the amount of people asking the questions, and so, I mean, the way we're addressing it now, when we get asked that question, it's really, I think the two of us, we've had this discussion before, is let's just look at that, but let's look at what journey you're taking. It's not just saying, hey, let's put it in an SPV, because if you're going to do a Reg A, I mean, what's the purpose, right? Like that's my view on it. If the long-term goal is that, but there's something interesting that's happening though with an the entrance, and I wonder if you can cover this one, Marty, is that obviously most of the people that are traditionally known about SPV, have invested in SPV, has been in real estate. So it's a project, it gets put there, boom, the company doesn't even see it. In fact, but this one is different. This one is dramatically different, because even though from my understanding, correct me if I'm wrong, is that regulators are saying, yes, company ABC, you can put the investors in an SPV, but you're still managing that SPV, and you still need to report to them. Is that, I'd like to hear your comments on that.
That's correct, and they're still investors in your company, right? And so we've had discussions with this, and I represent service providers that their whole business is forming SPVs and managing those, and we've had discussions about that, and if they form an SPV and they have a manager, is that sufficient? There's not a clear answer yet. I think we'll kind of understand that, but I think the overriding concept is, yeah, those are still investors in your company. They're going to invest through the website, and they will, Jonathan could probably talk a little bit about this, but you're still going to have to issue reports to them. It won't just go to a single person who's then responsible, as far as I know. I mean, maybe there'll be some evolution in that, and that process can be simplified. But the idea is they're still investors. They still you have to provide them the updates. You have to provide them the reports, and correspond. And when I say you, I mean the issuer. The issuer will have to continue that communication and make sure that they're managing them, even if they do just sit as one single shareholder on the cap table. They're still investors in your company, and you have fiduciary rules there, or obligations there.
Yeah, of course. The key element, what I'm getting from your comment is basically, even though you're able to put it there, you're still the one that owns that entity, and you gotta manage it as if it was here. What this is just giving you the ability is to show as one holder. It's just that and the reason I'm emphasizing this point is because you can't imagine how many people I deal with, and I'm sure we all do, where they think they're going to put it in an SPV, somebody's going to do the management, and say, oh, I'm only going to have one shareholder. No, you still have them all. It's just, it's going to show one on the cap table, but you still got all the other issues to deal with. You got to pretend they're still there. Like this is the emphasis that at least I'm making an effort. I don't know, Jonathan, from your end, is it the same?
Yeah, that's I mean, there's still a couple of concerns with the SEC's rule, and how they, wrote some of the rules. And again, hopefully we've definitely seen them willing to make some changes going forward. But for example, in Europe, it's a nominee system. And so a lot of crowdfunding portals in Europe, actually, it becomes the crowdfunding portal itself that is the manager of the SPV. And it really truly is. It's, the crowdfunding portal that does the management, and then it reports to, the issuer just reports to that one entity. So much more like a real estate. As Marty mentioned, the SEC didn't provide much guidance or clarification on who is the manager of an SPV. So that's still going to be something that's going to be really interesting. And I'm sure Marty's going to have a lot of fun writing the legal documents for these SPVs, really trying to clarify that without guidance from the SEC. But that's definitely going to be one of the things that we are very clear with on our issuers, is you still have these obligations, and you can't, just because your investors are put into one vehicle and you put a manager in charge of that vehicle, that doesn't mean that your obligations are done and you only have to do it to that one individual or the group, whoever's managing. You still have to report to each individual. So from a cost perspective, in terms of complying with the follow-on rules, it's not going to mitigate much for the issuers. And so that's one of the things we really need to be clear with, that it's not going to be, an SPV isn't going to solve all of your problems, and you're going to need to make sure you're prepared to do the due diligence after you raise a campaign, because otherwise you're still going to get in trouble with the SEC and FINRA.
Yeah, actually, you brought up an interesting point, is that when you do opt for an SPV, it makes sense. You have to account for that additional cost, because there are administrators, depending on that you can retain to manage that. And I mean, I know we're struggling at the moment from an industry perspective. The typical SPV providers, they go, yeah, we're excited. How many holders are you going to be? 5,000? Yeah, no. It's the pushback has been, if you've got 100, 200, we'll do it, but we don't want to do 5,000 or 1,000. And the reason for that is because there's a reporting requirement, to your point, Jonathan. So it in the surface, it looks really, really good. And people like Marty will provide you here's the SPV model, here's this model and that. But I think that the underlying question is, what is the journey that your company's taking to do the capital raising that will assist you on the SPV? So, I mean, whether the SPV makes sense for a company. So, right now, I haven't seen any crafted. I mean, I'm if you guys haven't either, but Marty, have you done? Have you been approached yet to create an SPV yet for a RegCF? Have we gotten there yet?
We haven't, and like I said, I represent a company that they're actually based here in Utah as well. That's been their whole business, is setting up these SPVs for 506C offerings, and they worked with Seed Invest and a lot of the platforms. And so I anticipate it'll be the same. Now, again, they're a third-party administrator. There's fees associated with that. They charge you fees to set up the SPV. They charge you fees to administer it. They'll handle the tax, tax issues and distribution issues, and they'll handle all of that. But again, there's fees, so that's something you have to think about. But I don't anticipate it will be, significantly different. The actual SPV setting up is pretty simple and straightforward. I think where the rubber hits the road would just be, like Jonathan mentioned, who's going to administer that? Are the platforms going to be the administrators of those SPVs? And if so, is there going to be a fee for that? I would expect so, because there's additional work. So I think there's nothing too, out of the ordinary. I think it'll be very similar to what we did with 506C, these types of entities for 506C. I mean, basically you're setting up an entity. These investors will have very limited rights. They're probably won't have. I mean, they're not going to be able to vote on a lot of things. I mean, I think their rights are going to be very limited, which is not unlike a SAFE or something now. So, but that's just something there'll be some additional disclosure in the Form C that we're going to have to add around these SPVs. I think there will be additional risks. There'll be I think some additional. We haven't seen anything from the SEC about what we have to provide, but I suspect you're going to provide information about that SPV, the administrator, the manager, voting rights, all of that. So it'll be interesting. I haven't been approached yet, but I think
so. But if somebody was, but let's take the scenario actually. And Marty, you're right. We haven't. I think everybody's curious, but let's talk about now the ideal scenario client where the SPV makes sense. What is that ideal? Maybe we can take it from that approach, right? They're raising $5 million, right? So what are the key trigger questions that's going to say, you know what, the SPV is the right vehicle for you? What kind of what items are there? And I'll come back to you, Jonathan, as well, because you're the funding portal.
Yeah, so I would think it's going to vary. I mean, I think there's a lot of circumstances, like Jonathan mentioned. On a $5 million raise, you're potentially bringing in a lot more investors. So that might be a primary consideration if you're the amount you're raising. The other might be, if it is an equity investment, and you have a valuation, then you might swing them towards that. Otherwise, one of the other reasons why people use a SAFE is that it's a startup. They don't have a firm valuation yet. And so SAFE is a nice instrument because you're not pegging a valuation for the company or being asked to do so. So that would be another time that a company might veer towards a SPV, is they have a valuation, perhaps they're trying to set one. The other thing is, and I haven't looked at this yet, but it was just as I've thought about this, it might be useful in the type of investments. So say, for example, you need to do an equity investment, maybe a debt investment. Maybe it's a real estate project, and it's easier to say, hey, we want to go into this project. This real estate project is debt. So we're going to form an SPV, and that SPV then is going to turn around and make a loan to the entity, the issuer. That might be a possibility. I don't know. I haven't crossed that yet or played with that with any of my clients yet, but I think that could be a potential as well. I think it just opens up a lot of possibilities that you just didn't have before in a lot of different fields. And like I said, if it's more project specific, so say you're trying to raise capital for a specific project within a business, you could set up an SPV, and that SPV is related to that project. So I think there's a lot of uses for it, and it will be up to the platforms, the issuers and their attorneys and advisors to kind of navigate through that.
That's perfect. And Jonathan, back to you, sir.
Yeah, I'll just piggyback off the kind of last point, Marty. The type of raise is going to be really important. Like I know we're working right now with a group, and it is a real estate investment, and we're trying to structure it in a way that makes sense for a crowdfunding campaign. If we did an SPV, if the SPV was available, it would be easy. And so definitely if a type of investment comes through the door, that's something we would work with the issuer on. And this goes back to Oscar. We had our a webinar last week. The preparedness of the issuer is really going to be important. As Marty mentioned, there's going to be a lot of cost to this, and you don't necessarily, just because you launch a campaign doesn't mean you get that money. This isn't Kickstarter. You have to reach that minimum. So if you're going to undergo the cost of starting up an SPV, before you do that, I'm going to say, one, can you afford it up front? All the costs of the SPV and the crowdfunding campaign. And two, do you have people who are going to invest right away? Because if you're not going to reach your minimum investment, you've set up an SPV for a failed crowdfunding raise, and you've basically wasted that money. And so I think preparedness, it's one of those things that we have to kind of talk with people about. They always have the next home run company and everything's going to work out great with this raise. Well, that's, unfortunately not true a lot of the time. And so, that's going to be a big one, is SPVs aren't for everyone, and they're costly. And so I think the big ones are going to be, are you ready to raise money? How much money are you trying to raise? And then the type of company that the type of issuance that you have will be the three major things we look at.
Well, in listening to the both of you, it as an entrepreneur, I would say, well, that's interesting, because the whole thing about regulation CF was to make it easy and smooth and coming in. And Marty, I know you and I deal with that with clients all the time. We try to it seems like the SPV it's going to be a little bit more bumpier, because there's a lot of ambiguity about the unknown, and that unknown, as we all know, will have an additional cost. And as to your point, Jonathan, when there's so much additional work to be done to marketing your offering, balancing the dollars and cents of back and forth. Excuse me. So one thing that strikes in my mind, and I mean, we will all run into an entrepreneur like this that will say, I only need $5 million and that's it. That's it. That's all I need. And I've dealt with it. I'm dealing with one right now. I only need 5 million, and this is a home run. I said, okay, look, I would say plan for the best, which is 5 is all you need. But what if you need, no. If I need more, I did something wrong. I said, well, okay. So this individual, it's 5 million and nothing else. They won't look at doing it a Reg CF again or a Reg A, nothing else. And because they're set on the SPVs, the ideal scenario, because they only have to deal with one holder. And I bring this up because and within the audience, I'm sure somebody's thinking, I only need 5 million. I only want to show one holder there, and I just want to put the holders on the side. And again, I'm iterating this back because everybody's trying to look for what is the ideal scenario client for this particular vehicle. If I hear it correctly, you guys can correct me. One, you obviously need to plan to have additional capital, which we don't know yet what the true cost is yet from the SPV providers. I'm sure we'll find them, and then the reporting requirements. And then two, what effect could this have in your long-term journey as the company proceeds? So I'm going to go to that point now, and I'm going to go to Marty on this one. So Marty, you and I deal with a lot of Reg A's, right? So Reg A, the beauty of that regulation is, for those who are listening in, the Reg CF is 12-month hold, Reg A, no hold, but once they're combined, which they can be, it's a glorified. So what happens if the company chose to do the SPV, but then makes the choice to do the Reg A? Where is the balance, or is there a balance? You're on mute, bud. I like that part though.
There we go.
Let's see, the stars look nice.
Yeah. So, there are considerations that you have to think about. And we talked about this actually in our last little webinar. And if you're thinking about the process and I think it's always smart to think about capital raising in a process and saying, okay, what's our next step? And if you are going to do a Regulation A offering, how is that going to look? Now, that SPV could sit on your cap table and you could raise additional capital under Reg A. Now, one of the benefits of a Reg A offering is that you can register up to 30% of the current up to 30% of your raise can be current shareholders, right? And so a lot of times an issuer will take advantage of that, and they will qualify, they will include part of their current shareholders as part of that Reg A offering, and therefore allowing those to be unrestricted shares. So if you have this SPV, how does that work? You would have to, it becomes a little bit more complicated because the SPV holds the shares, not the individuals. And so there would have to be, you'd have to basically unwind that SPV and then distribute the shares to them, and that there's securities implications of that. So it's not impossible. It's just something you have to think through. It doesn't prohibit doing a Reg A in the future. It's just something you have to think about and say, okay, is that something we're going to do? And is doing a Reg CF and having these shareholders sitting on our cap table, how does that affect it? But that happens if you do a SAFE as well. I mean, if you do a Reg A, you've got to, potentially convert those shareholders or convert that instrument anyway.
Okay, but that's an interesting point you brought up there. So I get the SAFE because the SAFE is directly into the company. So could the SPV be something that you utilize and then it can convert right back to the company again? Can it be written that way? Is that what I'm hearing, or I'm misunderstanding this part?
So you could. I don't know. I'm thinking about this on the fly.
No problem. No.
But you could have basically like registration rights that associate with that SPV, so that if you do a Reg A plus, that they would be included in that process, that those shares. But again, you'd still have to figure out. You'd have to figure out the best way to get those to the actual shareholders, and there's going to be securities implications associated with that. So again, it's not out of the realm. It's just something, and that's something to think about. I hadn't thought about that, but just adding those sort of registration rights or qualification rights.
Yeah, of course.
Into that. So
and
that's
Jonathan, I'll bring that back to you because I mean, I've never asked you. I mean, you're just looking at it from the RegCF. You're trying to, but obviously the journey could continue. They could come back again, of course. You like that to do a RegCF, but let's say the next race is 20, 30 million. Reg A makes more sense. Are you putting that consideration if they were going to undertake the SPV, or at this moment you're just going to put the SPV on the side?
Yeah, so we haven't had an issuer yet where jumping to a Reg A as their next step would make sense. I think as we get some larger issuers, that is going to be the case. So right now, yeah, if for those clients or those issuers that we do an SPV for, it would just be as simple as an SPV can get at this case. Obviously, it's very important to us that we design our offerings in a way that's attractive to the next round of financing. But right now, for most of our issuers, the next round of financing is either another crowdfunding campaign or then stepping up to VCs and angels. So I think maybe our company is just a little too in its infancy to be doing some of the larger Reg A deals yet. So that's something I'm certainly I'm getting prepared for down the road. So, but yeah, our SPV plan right now is we're going to be very selective with its use and, try to make it as simple as possible for management going forward.
Yeah, it does seem like in this conversation we're having that for those who are considering or thought that, how headlines are, right? Mm-hmm. I've read every headline. You can now do an SPV for a RegCF, and everybody's so excited. But then when you go into the weeds of it, it does change. So here's a couple more questions I have around it because I just want to make sure. So obviously we need an SPV administrator. There's a few companies out there that specialize in that, which will produce reports. So and then we have the legal entity here. So from what you've known so far, Marty, is the company having to do financial statements from both entities or just from the main entity to that entity? So this is it's
I don't know, but I would suspect the issuer is still, I mean, that becomes complicated because the issuer is actually the SPV, not the underlying issuer, the operating company. But I would think that just the financial statements of the operating company would be sufficient because those are really the only ones that are important. The SPV is not going to have it. It's going to be blank. So I don't think those would be important, but I haven't heard anything to that effect. I would assume it's just similar to like a 506c SPV, and you're really looking through that 506c, you're looking through that SPV to the underlying issuer.
No, that is these are all the random questions that are coming out. Like what happens here? Do I need 2 sets of books of records? I mean, the one thing that's clear is that even though there are 2, you still got to treat it as 1. And what does that all mean from a reporting element? But I think the bigger picture here is what I'm hearing is that because of the ambiguity, it's not something that we're all going to be jumping on just like that, because I think an SPV makes a great deal of sense for a larger deal. And when I mean larger deal, dollar amount to justify the cost and everything. Providers, I give them the dollar amount, they like it. They have no problems with the dollar amount. Let me put it this way. Anything from $1 million to $5 million, they go, yep, we can do it. So it's the next question where I fail. So next time I won't tell them that. And they go, so how many shareholders? And that's where, right? Because I go, all right, so companies that raised $1 million got 4,000. So if you're going to do 5 million, 5 times 4, it's the math game, right? They just get scared. They go, "You're kidding me." No, I'm not kidding you. That's the model that that's going out. So I think we need to figure that part out. It's like any other component in the industry. When Marty, this before you launched, Jonathan, I'll never forget 2012. Well, I know you remember, Marty, in the early days, everybody was talking about, so what's going to be the role of the lawyer if the funding portals are going to do the Form C? So people thought, well, you're not going to need a lawyer. You do. You still need the lawyer to review it. You need legal advice. That doesn't go away. Some people came up with a form filler program, which was great. It's a nice little, to accelerate it, but it doesn't change the fact that the Jobs Act did not say this is to help you raise money so you don't need the lawyers, the auditors, the broker dealers, or the funding portal. It was quite the opposite. And I think the SPV intent was the same, to use the current infrastructure. We just need to get the infrastructure so we have a little bit better clarity on that. So just a couple questions. I'll go to you, Jonathan, first. What would you like to have seen from the regulators for the SPV that you feel is missing, that kind of gives you kind of a wary moment as to whether this makes sense for a company or not?
Yeah, it's something we've kind of talked about a little bit. Is I think one of the things that the SEC, I'd like to see that they're growing, and raising the minimum to 5 million is great, but I would love to see this process simplified. Not just the SPV, but crowdfunding in general. As Oscar, as you just talked about, part of the gate that was in the way of a lot of entrepreneurs was just the cost and the complications of raising money because of the SEC rules. And crowdfunding has done a great job of making it a little easier, but it's still pretty complicated. I know, like, I was floored when I was talking with a regulator from the state of Georgia, and he said they had like a simple crowdfunding intrastate, and it was 2 pages, and you just had to file that. And I was like, I mean, that would be a beautiful thing. Obviously, for bigger raises, that's impossible. But if you're raising less than $1 million, why do you need to do a full offering statement and stuff? So I would have loved to have seen that from the SPV as well. Is like just like I think there should be a simple crowdfunding filing, there should be a simple SPV. And it would accomplish exactly what the SEC wants, which is you still have someone monitoring the rights of the investors, but they never really clarified who that is. And so it's up to a bunch of lawyers to kind of figure out. I'm a lawyer too, so I get it. It's up to a bunch of lawyers to kind of figure out and write these documents, as opposed to saying, all right, here's a very simple way for you to file an SPV. It only relates to crowdfunding. This, if you do a crowdfunding raise, here's a simple SPV. Here's who's in charge. Go. So I think that simplifying it, similar to, in Europe, like I said, they have that nominee system where the crowdfunding portal is actually in charge of the SPV. Something simple like that would have really made me a little happier.
And I think, Jonathan, I think that will come. I mean, heck, give me a call and we'll figure that out and put that in place. I don't think it's a huge hurdle. I think we can create something that's, and I think you'll see stuff that are really simple. You'll see basically really, one of the things will just be cost. Where are you organizing those? Are you putting that in Delaware or Nevada or wherever? But I think you'll create something that's really simple, a simple operating agreement. It's not, that's standard, and you'll see that kind of across the board. I think just like the SAFE has been sort of standardized and a lot of these documents have been standardized, I think that will come. I think it's just a matter of being asked to do that. But hopefully, and I agree with you, I think that it would be wonderful if we had something similar to what Georgia has done with their intrastate offering. That's a really simple process. Arizona has that. A bunch of states have some stuff like that, and it's nice. I think anytime you're talking about doing an offering across 50 states, though, it's going to be a little bit more complicated. So yeah.
But that actually brings up an interesting point, Marty, and that is that we shouldn't always wait for the regulators to tell us what to do. If they've given us a framework, we're diligent enough, and as Marty's offering here, here's an opportunity. I think the SAFE was the same way, wasn't it, Marty? Because I remember we were having these discussions even before RegCF went live. How are you going to deal with 12G and this and that? And then eventually, there's the SAFE, and then there's Republic with the crowd SAFE. I mean, ultimately, it was a creativeness of a lawyer, legal opinion, and making sure that everything was done accordingly. But does it change the mechanics, what the issuers need to do? Absolutely not. This was just a vehicle to protect you from Rule 12G, which is really why this is being created. But I like the way you open that door. I think that's where it starts. It starts here, constructing it, presenting it. And as they say, when the real key though within SPV that makes it a little bit different is that we still need another third party. But that being said, wherever that third party is, if they're listening in right now, this is your door opener. You got Marty Tate, you got Jonathan Furwer. You got to knock on their door to say, hey, I can do this. And I'm happy to say that as this conversation has been going on, our team has been talking to different sources and saying, we're really looking for somebody who can do K1s and nav reports for thousands of users. Are you scared of that? And most run away, and we're talking to one right now. So I'm going to play optimistic that we'll see where it goes. But if that is the case, if we can find, because we found out what the issue is. So it's like everything else. It's when you know where the problem is and why people won't take it on, is because imagine creating 1,000 reports. We go, oh, that's easy. Just click a button and it prints it. But the part that everybody forgot is the manual input. Somebody's got to manage. So there is the problem. Now we know where the roadblock. Well, guess what? Not that long ago, 6, 7, 8 years ago, we had the same problem. How is anybody going to ever do KYC if it's all being done on paper? And I remember lawyers asking, come on, guys, this is the way you do it. No, we're going to do it online. No. We still have a few of them out there that can't believe it. So we're evolving it. And so this discussion, for those who are listening in today, is not to discourage the use of SPV. We're just saying that the discussion has now begun, like in many other areas. We're in the second iteration or the second wave of the Jobs Act right now, which is exciting because we're being presented with a number of great things. As we spoke previously, the accredited investor can get involved, where before we didn't have that. Now you got an SPV. Well, the accredited is much easier to take on. This one, we need some thinking hat on to make it work. And I think, Jonathan, you touched on a great point. Looking at some of the examples from Europe where the funding portal becomes a representative. I'm rather curious from your point, Marty. I don't know if you know the new incoming commissioner. Just some high-level highlights on this new individual is very pro protecting investors. So if the funding portal becomes a representative of the SPV, let's just hypothetically say that that's a model we move forward with on, where is the rights of the holders in this case when the funding portal is the overarching, party for this investment? Shareholder rights.
And I think I talked about that earlier, I think they're going to be pretty limited, right? I mean, the shareholder rights are going to sit at the level of the SPV, and typically these SPVs will have a manager or an administrator. An SPV, if it's set up as an LLC, can either be member managed, which that means it's managed by the members, or it's manager managed. I think most of these, in fact, I think all of them would be manager managed. So those rights, and the way that they've been done in 506c land is that manager is vested with all the rights to vote, on any issue that's presented to the shareholders. That manager has the right to vote on behalf of the SPV. And a lot of times you'll have language in there that says that basically they just have to vote along with the majority, whatever it might be. So if a majority of the people are saying yes to this transaction, then you have to vote yes. So it's interesting. A lot of times those are just pre-dictated. So you're not going out to 4,000 people saying, hey, what should we do on this? That's the way I've seen it in the past.
Yeah, and Jonathan, I mean, obviously you brought up the example. I mean, how do you think they're having nominating somebody to be like the funding portal to be? Do you think you guys can take that on? If that, are you equipped from a governance and compliance structure to be balanced? You know, first bringing investments and then playing shareholder advocate.
Yeah, so I mean, right now we aren't because we're not allowed to do it. And so, but if that became, a source, because one of the things we're really restricted in what we can do as far as what we can collect fees for, and really truly all we can do is, collect fees for running a campaign. But if it came to a point where, like we could have a wing or a division that was like you have the onboarding of the issuer and then you had someone running the campaign, well, then we're done, really. That's really where the crowdfunding ends for us right now. But if we're allowed to continue on with those issuers and manage an SPV or their cap table or something, I mean, again, for us, I think Marty's been saying it, it's not that difficult for someone who's experienced in it to understand and manage an SPV and stuff. But we can't right now. And I would definitely feel comfortable, getting up a program where maybe not Wonder Fund itself, but like I said, just a consulting group that was related to us that we could pass it off to. We could definitely handle that. And especially because at that point, if we're designing, and you, Oscar, you're great about talking about the life of the campaign. If we get someone into our pipeline and they want to raise money through crowdfunding, and we know like we're going to do their campaign, and then we're going to do the SPV, and then perhaps the next round, whatever it is, we can design everything in a way that makes it really easy for us to manage all the way through, instead of having to pass it off from group to group to group as the life of the business grows.
Okay, so I mean, like I said, the conversation has now begun. There's a lot of choices in front of us. What needs to happen now is you got a little working group right now between a lawyer and a funding portal that could accelerate that to explore it. And but I think the way I'm going to look at it is the same way when RegCF first got introduced. The funding portals are going to have to take the lead on it with a lawyer, present it, and move on with it. And as we all know, people keep saying the regulars really don't like the SAFE, but yet here it is. It's working. It's not the prettiest instrument in the planet, by all means, but it's an effective one for now, and we can always improve. So for those who are not familiar with that, you'll encounter that as you engage with some of these funding portals. And there are many more that we are going to introduce here throughout these webinars. But we're up to that point now that we love to hear from you. I'm sure as entrepreneurs ready to raise money, you're probably wondering how this may work for you. So Michael, we're bringing you in right now. Ask away.
Can you hear me okay?
Yes, we can.
So what is the issue? Is it going to go to 75 million and 5 million? Because I saw where the regulators are questioning this and they want a 60-day holding period. I'm sure you saw the same thing.
So that's you missed the beginning. So it's official. It does go live March the 15th, 2021.
Really?
RegCF does, yes. And so does Reg A.
Oh, that's great. Thank you. I'm sorry. I must have missed the
No,
first.
no, it's okay. It's okay. Don't worry.
Perfect.
No dumb questions at all. All right. We got another one. David, shoot away.
Hey guys. What's really interesting for me about the SPV vehicle is the change in the fee that's collected by the portal, right? So instead of taking a broker fee like a BD model, you could be potentially taking the fee as a fund manager. In that case, do you think you would have to go and then register as an RIA, considering that you're managing, unaccredited investor money in the SPV vehicle?
So I'll take a shot at that. It kind of depends on the compensation structure. But say, for example, that you're acting as the manager, and there's a fee associated with that. One of the things in order to that in the definition of an investment advisor is you have to have discretionary control over the funds. And in this situation, there's no discretionary control for that the advisor or the manager. Basically, the money's going into this pool and they're investing it directly as the investors have stated, so that it's not going into a blind pool where they could then turn around and make investment decisions or have that discretionary control. So I don't see that being a problem.
Thank you.
Yeah, and I'll just follow on real quick. That's definitely one thing I have seen. I've seen people talking about kind of the evolution of an RIA or even an ERA, an exempt reporting advisor, like an office cropping up and doing similar to groups that do advising for SPVs. Maybe there's just RIAs out there that strictly do crowdfunding. But I think Marty's right in that it would be such a unique business model that I don't really know, especially early on in the process, who would really want to take that on, and whether or not it's necessary is, kind of still up in the air.
It for me is deja vu. I'm sorry. I have to. I don't know about you, Marty, but I'm having a little bit of deja vu moment over early days, just before RegCF was going on. I know for most of you, please appreciate this comment in the most positive manner. Is that it's great that we're having it again, because that means it's getting better. This is not a bad thing. If it was just like this, that'd be boring. But the fact that we're having to once again try to figure out things that need to work in to make this thing go, it just only goes to show you that the momentum that it's on. And the only great thing now that what we didn't have then is we have a lot of people that have been doing this for a while, both from the funding portal, the legal, the audit, so we can bring these experts very quickly, where then we didn't. It was just kind of you bringing people together and you didn't really know who would bring it on, and only a few materialized as the leaders, and Marty being one of them, Douglas Alanoff, another was Sarah Hanks, Louis Velacqua, Martin Roderick. I mean, there's some names that constantly come up all the time because they put their entire themselves into it. And if you don't notice it, that's where my gray hair comes from. So it's exciting. Lots of questions ahead. Is there any other questions here from?
Well, I actually had one following up on that too. And it kind of popped in my head. I was thinking about the explanation. So Marty, correct me if I'm wrong, but I believe the rule also says that these SPVs are one use, right? So you couldn't establish an RIA and an SPV and that invest in multiple crowdfunding campaigns. Like if you use an SPV for one crowdfunding campaign, that's it. That's all you can do the SPV for. So it's not like a mezzanine fund where you get a bunch of accredited investors who invest directly into private equity. It's strictly a one-use SPV too.
Correct. Yeah. The S sometimes stands for single purpose. So yeah, correct. That's correct. Yeah. And so that discretionary authority just wouldn't exist, because you're basically investing in that and then turning it around.
All right. So look, we're gonna close it off here unless there's some questions here from the audience. The discussion led that we gave you an overview what it means, how it can be used, what you need to watch out for. There still is some unknowns. The webinar is no webinar is going to be able to unravel it all, but you now have some thinking questions to deal with. But the key element that if you are looking to do in a RegCF and you are looking to do the 5 million, please talk to the experts. Reach out to Marty, reach out to Jonathan, we're more than willing to help you out to talk to them, but before you start making any decisions. So, and as always, speak to them in the most candid way you can, so they have a way to understand your journey that you're going to take. So this way they can specifically tell you what is the right path for you in this journey that you're undertaking, because regulation CF is only getting better. I truly mean that. I bought in 11 years ago. My goodness. Marty probably brought me in as well. We've been at this for a long time, and it's enjoyable. It's exciting. I'm pumped. Today, when I got the little message, it's a go. I was jumping out of my seat because probably like you guys, you probably have a lot of clients that have just been sitting on the fence with a little, I heard about this wording that they were going to say, yeah, we're raising $1 million, but if should something happen with a 5, we're going to go for the 5 or something like that, some legal wording. Now we don't have to worry about that. So I want to thank both of you today. Jonathan, it's always great to see you. Marty as well. Both of you will be coming back again. For the rest of you, thank you so much for spending this wonderful Friday afternoon with us, closing off the January. We have an entire great slate of webinars coming up for the month of February. We have 26 of them coming just in the month of, and you're going to hear from an array of different topics. There you can see them on LinkedIn. We'll be emailing them out. I want to thank you, all of you. Have a great weekend. If you want to see this again, they are being recorded. You can go to our YouTube channel at KoreConnex, YouTube KoreConnex. You can subscribe. You'll get all of it there. Anything you need from us, just reach out. We're here to help. Have a wonderful journey today. Thank you, Jonathan. Marty, we'll be talking soon.